Oh, Mr. Chair, far be it for me to sit back and be lectured on peace breaking out by a member of the Labour Party, and who, by the way, has used his 10 minutes to do nothing other than to insult, to insinuate and to show why he is likely to be now the second Justice spokesperson, about to be followed by the third from the Labour Party that I've had to deal with in the last 2 years. So let's just give him some facts, which is that it is not at all abnormal, Mr. Little, for people involved in matrimonial disputes or family disputes to in fact reach agreement regarding their children without going to court. So if we listen to Mr. Little, we'll hear it is absolutely ridiculous for me, and he went on to call me all sorts of insulting names, to think that it is that people should actually put their children first. Well, actually, that's just not true. Only 20-odd years' experience in the real world in legal practice tells me that actually it is absolutely normal and usual for people to, in fact, arrange these situations and resolve them themselves. What is abnormal is rushing into court about where a child is going to spend Christmas or a weekend. That is abnormal. But if you listen to Mr. Little, you think that that's the normal behaviour, and what's abnormal is actually expecting loving parents to put their child first. That is a very, very dim view of the world that Mr. Little had, and I have to say, if I was sitting in the back seat of the Labour Party at the moment, I'd be feeling a bit dim too. But there you go, Mr. Little does, so I forgive him those awful insults, because I'm that sort of person. Now, he's also got, but I'm sure he knows he'll get back double one day, and forgiving. And I can see Phil Goff wants to be forgiving too. Now, the other issue that Mr. Little raised was the issue of accountability. And he said that the Secretary of Justice could appoint anybody that he wants to have the role of an FDR or Family Dispute Resolution Service provider. And then he said that he went on to say essentially that I should be, as the Minister, should be making those appointments. I should be accountable for that. So on that basis then that I could pick anybody I like. But actually what he's failed to recognise, if he only turned up to Select Committee a bit more often, he might know this, is that there is in fact a Select Committee process around the estimates, around the financial review, where the Secretary of Justice is in fact absolutely accountable to members of Parliament and members on that Select Committee, and can in fact be questioned about that. At the same time, there's this thing called written questions, which Mr. Little could always write to me about this issue if he was so concerned about the appointment of a provider. And there's this other thing which he's not allowed to use at the moment, and that's oral questions to me about this issue if he's so concerned about it, about someone being provided with a contract that they shouldn't have. Well, quite clearly, we want to be able to leave the Secretary of Justice the ability to use his or her discretion to get the best providers of this service. And the last thing that I want to see as a Minister is to have the Secretary of Justice tied up in judicial review from disappointed people, providers of services, who don't get what they want. I want all the money in this area going to the people who need it, the people who are, in fact, the people trying to use the services. So there's another thing that Mr. Little could use, and that's this thing called an Official Information Act request, and he could use that too, but it's not for me to tell him how to do that. He should get advice from his new senior whip, who I'm sure would be able to help him. She's doing a much better job in ACC these days than what he ever did. But anyway, Mr. Chair, the critical element in family dispute resolution is something which actually says, let's create a system that provides a faster, less adversarial resolution of parenting issues. Because for most people, this is what they want. Most people do not want to spend years in court, going in and out of court regarding their children's issues. But Mr. Little's also said that some people will not be able to access this because of various reasons. And Mr Chair,
The Honourable Judith
and I
Collins.
think it's very important to note that where there is violence, and the question that was asked in the previous part by Mr Farfoy was about violence and how would people be able to access the courts. Well, because under the bill, and I suggest he reads it too, under the bill, if there is an accusation of violence or any evidence of violence, and that of course also involves the economic violence that we have now brought into the definition of domestic violence, then this will be fast-tracked. This issue will be fast-tracked. And Mr Little's also raised an issue that people will claim domestic violence. We might make claims on this to get into court before a judge. Well, under the bill, as amended in the SOP, a judge will be able to, if they see any evidence of the courts being misused in this way, to get that matter back into the Family Dispute Resolution Service, because I believe it is absolutely crucial that we enable people to make good decisions. And it's all very well to say people are upset, and yes they are. And yes they are, but ultimately most people already resolve these issues themselves, the vast majority. But I have certainly seen instances where people have been encouraged in a family dispute issue into court, when the best thing for both of those people and their children is for them to be able to sit down with somebody who is absolutely neutral to help them to resolve the issues. And that's where people's focus, their attention should be, on their children and how to resolve these issues. Only people appointed as FDR providers by an approved dispute resolution organisation, or the Secretary of Justice, will be able to provide FDR. So it's not the Secretary of Justice just sitting there deciding this person, that person. It's actually an approved provider. And the government SOP sets out what will happen to FDR providers when their dispute resolution organisation's approval is suspended or cancelled. And where a dispute resolution organisation is suspended, the organisation will continue to be responsible for their current FDR providers, and the FDR providers will continue to be recognised. Part 3 defines the duties of an FDR provider. Part 3 also provides for a number of regulation-making powers. Dispute resolution organisations will be approved in accordance with criteria, which Mr Little's forgot, set out in regulations, which still need to come into force. So it's not that there won't be criteria, but the criteria will be in regulations. And I think that's a very sensible thing, because we know it takes a long time for legislation to come through the House, and it may be that the criteria needs to be changed more quickly to better suit the circumstances of what we've found. So there will be criteria. It's not willy-nilly, as Mr Little says, but if he was at the Select Committee a bit more often, he'd know. And in fact, it will be set in regulations, and if he wants me to let him know what they are, I'm sure I will, because I'm just that sort of person, really. Now, the suspension or cancellation of approval must also be in line with grounds set out in those regulations, and that likewise regulations will outline the qualification and competency requirements for FDR providers and the matters that disqualify a person from being appointed as an FDR provider. So all of the talk that we've heard this afternoon about how it's just going to Secretary of Justice willy-nilly appointing anybody that he wants and no accountability, utter rubbish, Mr Little. Read the bill, read the amendments. And where the FDR provider, well, Mr Little wants to call me, what, Marjorie somebody? No, my name is Judith Collins, Mr Little. But anyway, having said that, he is into insults. Where the FDR provider determines it is inappropriate to start or continue FDR, they will provide the parties with a form stating their opinion as to why FDR is inappropriate. It may be inappropriate both because the parties are unable to take part effectively, or because at least one party or the child has been subjected to domestic violence by the other party. FDR may also be inappropriate because one party refused to attend or continue FDR, and that is absolutely crucial. We can't have one party holding up the other or holding up resolution of these matters for their children. Thank you, Mr Chair.
Call Jacinda Ardern.
Thank you, Mr. Chair, and thank you, Minister, for another friendly engagement. I really find it outrageous